Good morning, everyone. Yesterday we discussed the block one of BFEE elective. Today we will start with the second block, which is on policies and programs for family welfare. Under this, we have Indian family in transition, family planning policies, family planning methods and spacing between live births, and the medical termination of pregnancy and issues associated with it. Now, when we look at the Indian family, or if we look at any family, there are certain characteristics which are present in the family. There is family coercion, which can be defined as the emotional bonding between the family members towards each other. The second is family communication, which is defined as both verbal as well as non-verbal behavior that occurs within the family and also between the family and its social environment. Then is the role performance. Each family member, as we had seen yesterday, has a different role and they have to perform different roles even within the same family. The role of a father, role of a son, role of a husband, similarly for wife also. The role commitment is the evaluation of one's own and another's performance. How committedly or how much, to what extent the person is able to actually fulfill his or her role. That is role commitment. Now, within a family, there are several problems that can't be, which families could have. There could be different types of problems in different families. Now, there could be families with individuals having problems. This could include families of disabled families with disabled members, or someone who's chronically or terminally ill. It could be families of substance drug abuse or drug addicts or alcohols or whatever, substance abuse, which includes all everything. There could be problems with childbearing, families who have problems with childbearing. That could it could either be infertility or it could be unwed motherhood. There could be families who are facing marital problems, where it could range from marital disharmony to right up to marital breakdown. There could be abuse and violence in the families. Then there could be child abuse in the family. There could be family violence against women. Could be elderly abuse in the family, abuse of the disabled. So these are all the different kind of abuses which could be present in families who face violence. Now there could be families in conflict with other systems. Here it could be families with unemployment or indebtedness, where they have a huge loan which they have taken from different sources. There could be families with inadequate or no land or housing. Another type is families affected by disequilibrium in the other systems, which means that if there is a problem in the other systems, they are impacted by those issues. So these would include families facing political violence, people who live in regions where political violence is ongoing. Naturally, the families will be impacted by that. Then there could be families facing environmental disaster. It could be uprooted refugee or migrant families. There could be families with family deprivation. In deprivation, there could be, under that, it could be destitute children, destitute aged, or destitute adults. So these are the different problems that could be encountered by families. Now, as far as government policies and programs for families are concerned, when we talk about social policies in the family, India has a very explicit policy with an explicit goal for the family only in the form of family welfare program, which was introduced in 1977 by the Ministry of Health and Family Welfare. Now, in this program pursues family planning as an integral part of the comprehensive policy, which covers the total healthcare delivery system. However, though it talks about total healthcare delivery system, the policy has a very limited goal, clarity, and planned parenthood with one or two child norm through the independent choice of family welfare methods. The family welfare methods can be chosen by the couple, but the main aim, however, is to promote planned parenthood. The second is National Policy for Children, which was introduced in 1974. It aims at the full physical and mental and social development of children. As far as family is concerned, it states that in organizing services for children, efforts would be directed to strengthen family ties so that full potentialities of growth of children are realized within the normal family, neighborhood, and community environment. Which means that though the focus is child, the efforts would be directed towards a family and strengthening of family ties so that the child realizes their children realize their full growth potential. Then the National Housing Policy, which was introduced in 1988, it aimed at the eradication of homelessness. It also, one of the objectives was improvement of the housing conditions of the inadequately housed, and also provision of minimum level of basic services and amenities to all. Then in 1987, the National Policy for Child Labor, the National Policy in 1988, the National Policy on Education 1986, and the National Health Policy in 1985 also are there, which aim at specific services for specific or select groups of individuals, and the implications for the family are implicit here in these policies. India also has a forest policy which aims at protection, conservation, and development of the forests. Now, a draft of the National Policy for Aging is still under discussion. A national policy for women is yet at the stage of recommendations of the National Perspective Plan for Women. Our social security legislation is applicable only to the workforce in the organized sector, which means that more than 90% of the workers who are working in the unorganized sector are not covered by any social security legislation. A large number of families at risk remain uncovered by any social security against poverty, old age, disability, illness, and environmental disasters. Now, we have looked at the policies that are present in India. Now, the what we shall now discuss about the human rights in the family. Does a family have a human right? Now, what is human right? According to the United Nations in 1987, United Nations said that human rights could be generally defined as those rights which are inherent to our nature and which without which we cannot live as human beings. Which means the minute an individual is born as a human being, he is entitled to the human rights. Now, some of the instruments that are applicable to the family are the UN Declaration of Human Rights 1948, the UN Convention on the Elimination of All Forms of Discrimination Against Women 1976, and the UN Convention of the Rights of the Child 1989. Okay. Now, we just spoke about family planning and all of that. So, planning for family and for it is necessary that to have children or to have a family, to increase the family, planning is very important, and also responsible parenthood is crucial to an a conducive family environment. The decision to marry and to bring the children in the world is a couple's decision. It should be a couple's decision rather. It should not be a forced decision by the in-laws or only the husband's decision. It should be the couple's decision. They must responsibly prepare for parenthood so as to provide for themselves and their children in an environment in which they can grow personally as well as a family. It is not just enough to give birth to children. It is also important to provide not only for the children but for themselves also. The couple also need to take care of themselves so that there is an environment in which each one grows personally as a person and also they grow as a family. So, in such a scenario, Every child in the family will be a wanted child and not a product of chance. Very, very important. It should not happen that, the child was not wanted or unwanted. If there is planning, then every child will be a wanted child. It should not happen by chance. You don't leave it to chance. Every pregnancy will place the husband and wife in a new human setting and far from experiencing pregnancy as a pathological condition. If you are not prepared, probably pregnancy would be looked as a cumbersome and a pathological condition. But if you are prepared for it, then you look at it as a new experience, a new setting, human setting. Now, what do you? Now we discuss what are the aspects of a responsible parenthood. We saw that it should be a responsible parenthood, but what do we mean by responsible parenthood? It means having the knowledge and respect of their functions. They should be aware what is the function that they would have to play, or what are the roles that would change as a parent. What is it that they would have to do? The deliberate and generous decision to raise a family, or by the decision made for some motives and with due respect for the moral law to avoid for the time being or even for an intermediate period a new birth. The second is the responsible exercise of parenthood implies that husband and wife recognize fully their duties towards themselves, towards the family, and towards the society. Now, this is what we called, we discussed, it should be a planned parenthood. Now, what are the different family planning policies in India? What is the definition of family planning? Now, an expert committee in 1971 of the World Health Organization, they defined family planning as a way of thinking and living, both thinking and living, that is adopted voluntarily. It is voluntary, it is not something that is forced. Upon the basis of what is the basis of this thinking, knowledge, attitudes, and responsible decision by individuals and couples in order to promote the health and welfare of the family group and thus contribute effectively to the social development of a country. So there are several parameters in the definition of family planning. The first is that it is a thought process. It is a thought process which is translated into your living. It is a way of both living and thinking. And this thought and thinking and implementation is adopted voluntarily. And what is the basis of this thinking process and living process? It is the knowledge and attitudes. And very importantly, responsible decision by individuals and couples. To do what? To promote health and welfare of the family and thus contribute effectively to the social development of a country. Ultimately, what does the country constitute of? Society. What does society constitute of? Families. So if the family functions effectively, naturally, it will contribute positively to the development of a country. Now, what are the objectives of family planning? There are some basic objectives and important objectives of family planning. The first is to avoid unwanted births. Second is to bring about wanted births. Third is to regulate the intervals between pregnancies. Fourth is to control the time at which births occur in relation to the ages of the parent. Very, very important because the health of the mother is very adversely impacted if the mother's body is not physiologically, emotionally, and physically prepared for a pregnancy and motherhood. So, to take care, to plan and to control a time when the body is actually prepared. Though at 18 is a legal age of marriage, the girl or the woman is still very young and immature, so she needs time to really get physically and mentally mature. So whatever time they feel is the most, apt for pregnancy. So to control that time, so that immediately after marriage, 18 years, 19 years, a woman doesn't have a child. To determine very important, to determine the number of children in the family. So these are the different objectives of family planning. Now, as far as family planning programs are concerned, it has been discussed in detail in every. We all know that India followed the 5-year plan system. So in each plan, the detailed discussion of family planning programs has been done in your notes, which you can go through, which I will not go through in detail. Now, the next topic is family planning methods and spacing between live birth. Now, there are a number of methods which are commonly used by people for family planning. The most widely used method is the condom, which is used throughout the world on a large scale, and it is a barrier device which is used by males. In India, it is actually it is a brand name, Nirod, but it is on new condom is known by its brand trade name, which is called the Nirod, a Sanskrit word meaning prevention. Now, it is receiving attention today as an effective, simple spacing method of contraception without any side effects because it is hassle free and it is easily available. It is effective and does not have any side effects. In addition to preventing pregnancies, it also protects both men and women from sexually transmitted diseases. You know that there is a high prevalence of AIDS and other sexually transmitted diseases. So the condom also protects both men and women from these diseases. The second type of most commonly used method is the diaphragm, which is a barrier which is used by females. It has a flexible rubber run made of spring or metal. It is important that a woman be fitted with a diaphragm of a proper size. So if it is not proper, it will not work. The diaphragm is inserted before sexual intercourse and must remain in place for not less than 6 hours after the sexual intercourse. A spermatical jelly. A jelly is used along with the diaphragm. Again, here there are no side effects. They are practically nil. The third is the IUDs or the intrauterine devices. These are in this what happens, a foreign body is introduced into the uterus and which physically prevents pregnancies, the sperms from entering the uterus. Fourth is hormonal contraceptives. When they are used properly, they are the most effective spacing methods of contraception. They provide the best means of ensuring spacing between one child and another. Hormonal contraceptives currently in use may be classified as oral pills, which under oral pills there are several types. It could be combined pill, it could be progesterone, it could be postcoital pill, or it could be once a month pill, or it could be a male pill. The second type of hormonal contraceptives is the depot, which is slow release formulations. It includes injections, subcutaneous implants, and vaginal rings. The fifth method is the post-conceptual methods, which include both menstrual regulation as well as abortion. The sixth is terminal methods, where it is permanently you are, uh, 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 ensuring that no pregnancy takes place, which is also known as sterilization. It could either be male sterilization or vasectomy, or it could be female sterilization, which is also known as tubectomy. Now, as far as family planning methods are concerned, there are several, the different religions have different views about these family planning methods. Now, though the Hindu ethics, they condemn abortion generally. but in normal circumstances, they would not approve of an abortion. But it accepts abortion on certain grounds, such as rape, incest, and when the mother is at the grave risk of injury or death. And again, also in Islam, the basic teaching of Islam is that life is a gift of God. Hence, the Quran warns men not to interfere with the work of God. It is on this faith that Muslims generally oppose abortion. However, like Hindu ethics, Islam ethics also permits abortion on the basis of pregnancy, which endangers the mother's life, and where it is a result of a rape which does not result in a marriage. Similarly, even in the Catholic or in the Christians or Catholic, Christian religion or among the Catholics, abortion is condemned. They do not approve of abortions. Christianity encourages couples to have self control and promote natural family planning methods. Christianity considers abortion a grave sin and calls it a murder. It is a murder of an unborn child. That is what they believe. Now, there are several implications of termination of the pregnancy, right from physical and medical. It impacts the health of the individual. It could be psychological and emotional. It has a very scarring effect on the emotions of the girl or the woman who undergoes the termination of pregnancy, and it could have long-term effects or impact as well. It could be associated with feelings of guilt of having actually killing an unborn or a unborn child. So it could have deep repercussions on the psychology and emotions of the woman who actually undergoes it. There are social implications of medical termination of pregnancy as well, because society does not generally approve of terminations of pregnancies. And again, as we just saw, that it also has religious and moral issues associated with it. Now, in India, we have the Medical Termination of Pregnancy Act, which was introduced in 1971. Now, what it talks about three things: the conditions under which a pregnancy can be terminated. That is the first point, which has been specified in the Medical Termination of Pregnancy Act, which means that there are only certain conditions under which the pregnancy can be terminated. Otherwise, it is not considered legal. Second is the person or person. It also specifies who are the person or the persons who can actually perform the abortion. Third is where the abortion can be done. It also discusses that in detail. So these are the three aspects which are discussed in detail in the Medical Termination of Pregnancy Act 1971. So here we come to the end of block two, where we have generally seen what are the major topics that have been discussed. Of course, we will not be able to discuss each topic in detail, but I have just given you an overview of all the topics that have been included in block two, after which we move on to block three. Now, the block three is mainly on major problems in marital life. It discusses the major problems which happen in marital life. Here, there are three units. The first unit deals with the psychosocial effects of divorce, separation, and migration. The second unit deals with dowry demands and dowry deaths. The third unit deals with the legal issues involved in marriage. Now, first of all, when we talk about, what is divorce? What is meant by the term divorce? Divorce is socially and legally recognized dissolution of a marriage. As the marriage has also happens legally, the dissolution also happens legally. So there are certain social and legal norms for a marriage to happen. Similarly, for a divorce to take place or for the marriage to terminate or dissolve, it happens through a socially and legally it has to have a social and legal recognition. Like marriage, it is governed by a variety of cultural and legal regulations. Sometimes the dissolution is by stages, which means it does not happen all of a sudden. It happens gradually, one stage after the other. For example, the sequence could be first would be trying to avoid the dissolution or trying to avoid divorce. Then there could be a suit for separate maintenance. Then it could be legal separation, and then finally an absolute divorce. So it is not something which can be done directly. There has to be a sequence, or there usually they try and follow a sequence so that by the end of it, the person is mentally absolutely ready and is sure that he wants or he or she wants to go in for a divorce. Now, when we talk about the causes of divorce, there are several causes of divorce. The first is attributed to modernization. What has happened is we have already seen earlier that there has been a disintegration of the family because of the urbanization, industrialization. There has been modernization, and the family has been hastened by free sex relations made possible by changing notions about morals and by birth control techniques. The second is growing acceptance of change. Now, priorities have changed even in a country like India, where hidebound traditions exist. Where the priority was the husband, it is now shifted to the careers as far as the women are concerned. The inevitable liberation by the woman, her economic independence, and Western influences has given marriage a new outlook, especially amongst the educated urban dwellers. The third is high personal aspirations. What has happened in the modern industrial society is that people are getting more and more ambitious than the people as compared to the people of the traditional societies. What has happened is, even at the cost of their family life, they pursue their career. Thus, the family has taken a backseat. Now, here we are not passing judgments as to what is right and what is wrong. I'm just trying to explain to you what is given in the text. So, this is what the text says. The fourth reason, which has been cited in your material, is growth of the nuclear family. What has happened as a result of the urbanization and industrialization is that the nuclear families have come into existence and they are growing on a large scale. The joint family system is slowly and gradually becoming disintegrating or getting lesser and lesser and is only now mainly seen in the rural areas. Now, the parents played a role of a mediator between the husband and the wife in the joint family system, but with the beginning of the dissolution of the joint family, it has brought about larger issues, and divorce is among the one of them. The fifth point is declining values. What is said is that there is a noted decline in the value system amongst the people. So probably they do not value family as much, and so the rates of divorce are increasing. Physical separation is an important fact when you don't live together. What has happened is there are more and more job opportunities in other cities or even in other countries. So now what the people are doing is they're giving up the village life and migrating to big cities, which could be within or even outside the country. Now we all know that when there is migration for work like this in big cities, whether it is in India or outside abroad, it is well known that housing facility is a very big problem. And so what happens is that the people cannot afford to take their families along with them. So what happens is that the families live separately. The wife and the children or whoever else is there in the family is left behind, and the husband moves to the city. So there is a physical separation between them. That also could result in a divorce. That also is one of the reasons of divorce. Now, what is the impact of divorce? Divorce has several impacts, and it affects the entire family. So, the first important impact is stress. The stress which is experienced, it consists of bodily responses, increased heart rate and blood pressure, dry mouth, rapid breathing, and so forth. Stressful events lead the body to undergo several minor or major physiological changes. These changes are very important to understand because they can lower the body's resistance to disease. It decreases the it impacts the immune system of the body, and it increases risk of diseases and illnesses. The second impact that it has is a low self-esteem and a feeling of failure. Divorce sometimes leaves a negative effect of reduced self-esteem on the partners. It can affect one's performance in day-to-day activities because there is a feeling that you could not make your marriage work. So there is a feeling of failure that which lowers the self. These feelings lowers the confidence and self-esteem of a person. Rise in aggressiveness or anger. Many a time, the negative emotions may lead to a mental imbalance amongst the individuals going through it, which can result in raised anger or aggression in the temperament. Fourth is depression. Divorce has been rated as the second main cause of stress for the partners and their children. The process tries a person mentally as well as physically, sometimes resulting in depression and a sense of regret that you should not have done it or it should not have happened. The fifth impact is rise in delinquency. It has been found through various studies that the major percentage of the delinquents and rise in crime amongst the youth result from children coming from broken homes or a single parent family, which means children of divorced homes are more prone to committing delinquent acts. Now, when we look at the efforts on the different target groups, the first is the impact on children. Children are the ones who are directly affected by the divorce of their parents. They are the sufferers of the dissolution of the marriage. The incapability of the adults to get along well affects the child negatively. It has a negative impact on the psychology of the child. Single parenting is a difficult situation for the child in all stages of his or her growth. Children are distressed with their parents' divorce. Children under the age of 5 may react with rage and grief, and they may also develop behavioral problems. The older children, though they're able to grasp the situation better, but sometimes they tend to blame themselves and take the guilt upon themselves for the divorce. The adolescents who themselves are in a situation of identity crisis. We saw that adolescence is a phase of crisis because they are neither children now nor are they fully adults. But now they're supposed to be more responsible. So when they are in that stage where they themselves have not been able to develop an identity of their own in society, they feel socially embarrassed by the breakup of their parents. This deprivation of an affectionate relationship is most damaging in early childhood. Naturally, there is a deprivation because if the child lives with either parent, the affection of the other families, parent is not there, and also that intimate and affectionate family bonding and relationship is absent. Deprivation can ruin the self concept of the child in childhood. So it has multiple effects, and it has the majority of the effects are on the children who are very negatively impacted by the divorce of the parents. The second is the effects on partners. The two persons who have up till now who shared a common goal, They all of a sudden separate, which naturally gives an emotional as well as a social shock to both of them. Emotional shock in terms of the habit of staying together, fulfilling the needs of each other, caring, and the love of and the bond of love, which suddenly comes as a shock. The process of divorce could be socially intolerable for both the partners. Now, the divorce also has an effect on the family. The growing rate of divorce and the breaking down of the family unit is posing a societal threat. Naturally, because since family is the basic unit of any society, the breakdown in the family will definitely affect the societal structure. Family, which is the basic unit of society, is negatively affected by the quitting of the partners from the marriage bond. Children, an important part of the family, are the worst sufferers of divorce. Even the parents of divorced parents, partners, face difficulty to cope up with the situation. It is difficult for them to cope up with the situation where their either son or daughter is left alone and their marriage has not been able to go through, or they have not been able to work their marriage out. The next important point, which is discussed in this unit, is dowry demands and dowry debts. Hmm. Now, when we talk about dowry, it is, a very deep-rooted evil in society. Now, how did dowry begin? Actually, in olden days, it was a custom, that the presents were given to the bridegroom and his family at the time of the marriage. Now, this actually they did in order to make a provision for the couple. If in case there is some situation or there is some crisis, they can fall back upon whatever these presents were given. So, in case of any need, they can use whatever gifts were given at the time of marriage. But what has happened gradually, and that unfortunately a practice has began where such gifts are being demanded either by the boy or his family or by the girl of his or his family. It's different in different parts. In some tribal communities, it is the family of the girl who demands the dowry, but in major parts of India, it is the boy's family who demands dowry, and they feel that it is their right to do so. So that is how the whole practice of dowry has become it has become a very vicious type of a custom or practice. Now, India has introduced the Dowry Prohibition Act in 1961. Now, according to that Dowry Prohibition Act, dowry is defined as a any property or valuable security which is agreed to be given by the party directly or indirectly by one party to another as a clause of the marriage. It could be by the parents of either party or it could be any other person. And the dowry could be given to any to either party of the marriage or any other person before, at the time of, or even after the marriage. Now, Dowry Prohibition Act 1962 has said that giving or receiving dowry is a punishable offense. That is what the Dowry Prohibition Act says. It says that it could be what all could be included in dowry. It could be property or valuable security. It could be agreed to be given or agreed to be given. Both of this. It's directly or indirectly by one party to the marriage to the other party before, at the time of, or even after the marriage, and it is in connection with the marriage. Now, what is the penalty for giving or taking dowry? If any person, after the commencement of this act, gives or takes or abets the giving or taking of dowry, he shall be punishable with imprisonment with a term not less than 5 years and with a fine which should not be less than 15,000 rupees or the amount of the value of such dowry, whichever is more. What this means is that there will be a fine. Now, what is a fine? 15,000, or if the person has asked for more value, the dowry has more value than 15,000, that what then whatever is the value of the dowry, that much fine. So whichever is more. If it is less, then also the person will have to pay 15,000 only, minimum 15,000 fine, provided that the court may for adequate and special reasons impose a sentence of imprisonment for a term of less than 5 years. Usually it is 5 years, but in special circumstances, if there is adequate and special reasons, the term could be lowered. Now, also, presents which are given at the time of the marriage to the bridegroom, no, which have been given out of free will and choice, and they have not been demanded, then they are not considered as dowry. Also, that such presents should be entered in a list, which should be maintained with the rule made under this act. Then it is not considered dowry. For provided further that where such presents are made by or on behalf of the bride or any person related to the bride, such presents are of a customary nature and the value thereof is not excessive, having regard to the financial status of the person by whom or on whose behalf such presents are given. Which means that there are certain customs in all religions during marriage. Now, for example, in the Hindu marriage among the UP, in the UP, there is a custom that there is something called as chunari, which is given by the sister-in-law, or which is given. So in that case, in case the sister-in-law gives the bridegroom some present which is a custom, then it would not be considered as dowry. But it also says that whatever presents are given, they should be as per the financial status of whoever gives it. Supposing the person is a very poor man who is living in a rented house and has a salary of 15,000, and he has given a house worth 10 lakhs to his daughter. It definitely means that it is not something which is in proportion to his financial status. So that would definitely be considered as dowry. Penalty for demanding dowry. But we saw what is the penalty for giving or taking dowry. But here it is, even if you demand dowry and somebody makes a complaint, then there is a penalty even for demanding a dowry. If the person demands directly or indirectly from the parents or relatives or guardians, all three are involved in it, of a bride or bridegroom, as the case may be, any dowry, he shall be punishable with an imprisonment for a term which is not less than 6 months, but which may extend to 2 years, and with a fine which may extend to 10,000 rupees. Now, here minimum sentence is 6 months, maximum is it can extend up to 2 years, and there is a fine which could be up to 10,000 rupees. Again, here provided that the court may, for adequate and special reasons to be mentioned in the judgment, impose a sentence of imprisonment for a term less than 6 months, which means in special circumstances, if there is adequate reason, the court or the judge may pronounce a penalty which could be less, imprisonment could be less than 6 months. Now, ban on advertisement. If any person offers through any advertisement in any newspaper, periodical, journal, or through any media, any share in his property or of any money or both as a share in any business or other interest as consideration for the marriage of his son or daughter or any other relative, it is banned to make any such advertisements. Second is, if he prints or publishes or circulates any advertisement referred to in the above clause, which we just discussed, he shall be punishable with imprisonment for a term which is not less than 6 months, but which could extend to 5 years, or a fine which may extend to 15,000 rupees. So even making any such advertisements where you are talking about giving a share or money or anything for consideration of marriage is illegal, and there is a punishment for that as well. This now the here what it is said is that this the dowry prohibition, as far as this is concerned, that it should be tried in no court which is inferior to a metropolitan magistrate or a judicial magistrate of the first class. Only they can try this offense, and the court can take cognizance of such offense only when it is reported by a police or a police report, or the complaint is made by a person who is aggrieved, or the parent or other relative of the person, or any recognized welfare institution or organization. Now, a recognized institution means any social welfare organization which is recognized by the state or the central government. Now, the government under this act has the right to appoint certain dowry prohibition officers. The state government may appoint as many dowry prohibition officers as it thinks fit, and specify the areas in respect to which they shall exercise their jurisdiction and powers under this act. Every dowry prohibition officer shall exercise and perform the following functions. One is to see that the provisions of the Act are complied with. Second is to prevent, as far as possible, the taking or abetting the taking of or demanding of dowry. Third is to collect such evidence as may be necessary for the prosecution of persons committing offences under this Act. The fourth is to perform such additional functions as may be assigned to him by the state government, or as may be specified and any rules made under this act. The state government may, for the purpose of advising and assisting the dowry prohibition officers in the efficient performance of their functions under this act, they may appoint an advisory board. The function of the advisory board is what? To provide advice to the prohibition officers in respect to the prohibition of dowry and in respect to their functioning. Now, this advisory board will not consist of more than 5 social welfare workers, and at least 2 of them have to be, out of these 5 have to be women. Also, they have to be from the area in which the dowry prohibition officer exercises their jurisdiction. For example, if the dowry prohibition officers are placed in one particular geographical area or in one particular city, for say, for example, Kerala, then you cannot have women officers from so welfare workers from Mumbai. They have to be from that particular area only. And the maximum number of members on the advisory board is 5, and out of which 2 have to be women. Now, there are also other provisions which there are different sections which have been discussed in your syllabus. One is the criminal procedure code, one the 498A of the CPC, which again says that it is said that if people commit cruelty against a woman, it is an offense and it would be punishable. So like similarly, there are many such acts which have been discussed in your syllabus, which you can go through. Now, there are certain things which there are legal issues which are involved in the marriage, and every specific religion has got different laws relating to marriage, which lays down the entire procedure and when they consider the marriage a valid or a legal marriage, and when and how divorce can happen. So different religions have got their different laws. So for this, it is necessary to understand all these laws. Now, there are, in terms of different religions, there is the provisions in the Hindu Marriage Act 1955. Then there are the provisions in the Christian Marriage Act 1872. Then there is a Special Marriage Act 1954. Special Marriage Act is for marriages that take place between individuals of two different religions, because they can neither be covered in the Hindu marriage or any other act if one belongs to one religion and the other belongs to another religion. So that there is that they can have a marriage under the Special Marriage Act 1954. And also there is the Muslim Marriage, Divorce and Custody of Children Act. They have the in Muslims also there is a code of conduct laid down for marriages, which you can go through in detail. It has been described in your syllabus, so in your study material. So, in short, I have tried to give you a brief view of what all are the different topics and what is the scope of the elective on family education, what are the different blocks covered under this, and what are the different units under each block, and also what are the subtopics which are considered which have been discussed in each of the units. So I hope I have been able to give you an overview and you have very good reading material, so you can go through all these topics in detail. So thank you very much and wishing all of you the very best.